New York Supreme Court at Westchester County recognized and enforced a judgment of divorce and custody of the children from Abu Dhabi when both parties were residing in Abu Dhabi, and a decree was obtained after a trial and two appeals, and both parties were presented by counsel and the court had jurisdiction. Hi, my name is Gabriel Sauma, a professor of Middle East constitutional law and Islamic law, and attorney with Middle East background. I'm expert consultant on Islamic divorce, custody of the children, and abduction of the children in U.S. courts. This video is one of a series of videos involving cases that I worked on during my career as an expert consultant. I plan to talk about this and other cases in future videos. One of these cases is this case that became a case study in U.S. courts in general. I worked on this case several years ago and will be glad to send you the link at your request. To see all my videos concerning Islamic divorce and custody of the children in U.S. courts, please subscribe to my channel. The question before the court was whether the New York court will recognize and enforce a divorce and custody of the children granted by Abu Dhabi court to the wife. We prevailed in this case at the trial court and at the appellate division as well, and the case became a case study in U.S. courts. So the question is, under what conditions the Supreme Court of New York's Westchester County ruled in our favor? Here is one factor out of several factors that I'll be talking about in the future. The general principle of law is that a divorce judgment obtained from a foreign country in accordance with the laws of the country is entitled to recognition under the principle of comity, C-O-M-I-T-Y, unless the decree offends public policy of the state of New York. The doctrine of comity is equivalent to full faith and credit given by courts to judgments of sister states. In this case, the Supreme Court stated the following: this means a party who has properly appeared in a foreign action is ordinarily precluded from attacking resulting judgment by bringing a collateral New York proceeding only where there has been a showing that a foreign judgment was fraudulently obtained, or that recognition of the judgment would conflict seriously with a compelling public policy. Can a collateral attack be entertained? The court added, absent some showing of fraud in the procurement of a foreign country judgment of divorce would violate a strong public policy of New York. The court said a party who properly appeared in the action is precluded from attacking the validity of the foreign country judgment in a collateral proceeding brought in the courts of New York, a judgment of divorce is immune from challenge under the doctrine of comity because such a challenge would essentially constitute an impermissible collateral attack on the foreign judgment. The court added, husband was precluded from collaterally attacking validity of provisions of Abu Dhabi divorce decree, where at the time of divorce proceedings, both parties were residing in Abu Dhabi. The decree was obtained after a trial and 2 appeals, including an appeal to the highest court in Abu Dhabi. Both parties were represented by counsel and had full opportunity to contest issues. And Abu Dhabi court had jurisdiction to issue final binding order over the matter. I will have more on this case in future videos. Thank you very much.